I think one of the more shocking things was the basic proximity of the accused and the accuser. In other words, the police very often are from the same neighborhood or live among the same group of people. And it's very much a there but for the grace of God go I, because otherwise they would have been in similar shoes. However, they are possessed of a badge and a gun and the ability to be the people doing the accusing. But there's a very thin line between the accused and the accusing here in the United States. I'm sure you have international listeners, but I can only speak to the American system. The other thing was the people doing the accusing are not possessed of superhuman ability to know and understand and apply the law. They very often get it wrong. And there's there's many opportunities, as my grandmother would say, many slip betwixt the cup and the lip. So where you have a police officer arguably out on the side of the road, he's going to call a duty DA, a district attorney who's on duty for that 24-hour period, to answer questions about what to charge and how to charge this person based on the facts that they have before them. And you have an incomplete set of facts and you have miscommunications, and sometimes the DA may not be answering those questions with a full picture of what happened, and therefore you have incorrect charges being filed. This happens very, very often, which is why at different stages of the case, you will have the matter resolved. So say, for example, if the first step for most people to see a judge would be at their preliminary hearing, and that's the first time that you're going to see the cop, arguably, or the detective for the first time, and you're going to know what they're charging you with rather than just seeing the complaint, which will be a list of charges. By the time we get to the prelim, we can actually cross-examine the police and see what the basis was for them bringing the case.
Got it. So also, one thing I feel like it's a lot of people, a lot of I won't say a men, but a lot of people, they assume that the courtroom is where the real battle happens, right? From your experience, what's the biggest misconception uh, like people have about where the cases are truly decided?
That's a brilliant question. Brilliant. And I'll tell you why. So, having done this for as long as I've done it, I will know the police officer, or I will know the prosecuting attorney, or both, or I will know the judge.
Correct.
So, very often, I will have a conversation with the DA in the parking lot or in a conference room, and I will ask questions that I'm not going to be able to ask when the witness is on the stand. So say, for example, if they're making me an offer that is an extremely palatable offer, there may be a tactical reason not to take a hearing, to not cross-examine this officer. If they're going to make me an offer in a conference room, based on prior experience of what I know about this DA and what I know about this officer, and I find it to be a reasonable offer, I will have communications with them because I've known them for decades. And we can be very candid with one another as to what they're seeking, whether or not they have the evidence, whether or not the witnesses can be produced, whether or not the integrity of the witness is, whether or not they're credible, whether or not the ability to produce evidence is real. So very often there's a lot of bluffing. So sometimes you'll have an officer get moved out of the jurisdiction, get promoted out of this office, and they will show up for the prelim but not be able to be produced at the trial. And a lot of people don't understand that if the officer can't be produced, if there's no witness, there's no case. So we need to know whether or not this person's going to be actually able to be called to testify down the road. These are things that you only know because you have your ear to the ground and you know what's going to happen. But you're absolutely right. Very often, the communications by which a person's life will hang in the balance will not happen with a stenographer recording the proceedings or a judge making a determination as to what's admissible and what's not. It's very often in the parking lot, in a conference room, on the phone. Sometimes we text each other, sometimes we email each other. There's communications flying around all over the place, which is why I tell people very often that my relationship or my job is much more about relationships than it is about the law. It's about whether or not I can trust this DA and whether or not the DA can trust me, that we're both being candid and open and honest with each other about what we want to do with this case and whether or not it can be handled in a fashion that all parties are satisfied.
So obviously, I mean, like, what kind of trends to be set in motion long before a trial that most defendants never realize is already shaping their outcome?
Yeah, that's a good question too. Very often there are things happening in the law that the client will not be aware of. So say, for example, last year there was a Supreme Court case, Commonwealth versus Shiflett, that had a great deal of bearing on Pennsylvania DUI cases.
Okay.
And what heretofore for the last 3 decades, someone would be able to get ARD on a case. ARD being alternative rehabilitative disposition, where we could satisfy essentially a set of probationary requirements, at the end of which the case would be dismissed and the record would be expunged. This would only be for first offense cases, wherein this is an anomaly. This is not, a normal course of conduct. They have no prior history, and it's a nonviolent case. If that is the case, then you could count on ARD being an option for you. However, Commonwealth versus Shiflett, which is very much, I'm going to use the expression inside baseball, a lot of people would not have known that there was a Supreme Court case or that it had any bearing on their life whatsoever until they're under arrest with a DUI prosecution. And what their neighbor or their family member previously could count on being ARD is now no longer on the table because of a Supreme Court case they knew nothing about. That's just one example. Now, since then, that case has been resolved. So now the legislature caught up to the Supreme Court, and now we have a change in circumstances, all of which 9.9% of the general public have no idea that there was a Supreme Court case, that the legislature had to consider this, or that the DAs were doing something differently than they had been for the last 3 decades. So that's why you're absolutely right. Things are happening away from people that they know nothing about, and they're ensnared in a system with changing variables all the time. And there is almost no area of the law that doesn't have changing variables. I'm in the criminal defense world. I'm sure it's the same way for divorces or family cases or, insurance law or whatever the case may be. That's why an attorney who's doing it all the time will have a better insight as to what the state of the law is at any given moment.
Got it. So the courtroom is often the final chapter and it's not the beginning.
Yeah, the courtroom generally is, something has gone very, very wrong if we find ourselves in the courtroom. We generally don't want to be rolling the dice with someone's life and future, which is exactly what you're doing. I had this conversation with a U.S. attorney, a prosecuting attorney for the United States government, and nobody wants to go to trial. And nobody wants to go to trial. When I say nobody, I mean the lawyers, the prosecution or the defense, because you never know what a jury or a judge is going to do. It's a very roll of the dice kind of situation for both sides. And that is not what a prosecuting attorney wants. They want to dispose of the case having achieved some semblance of justice and stopping other people from doing similar behavior, which you're more likely to secure by way of a plea agreement. If you go to trial, all of that is on the line. It's a big gamble, and nobody can tell you the outcome. Nobody can make any promises. A prosecuting attorney can't make any promises to the outcome. A defense attorney can't make any, not if they're ethical. They can't tell you that it's going to go a certain way because they simply don't know, and no one does, which is why very often you will see plea agreements because all parties can be made, satisfied that what they've got here is maybe not the best possible outcome, but the best possible outcome for everyone involved. They just stipulate that, okay, we're going to take an agreement that's been offered rather than roll the dice with my entire life by going to a jury trial.
True. Very true. Yeah. So let's take this for a moment. Like you have spoken about the prosecutorial discretion and also about the law enforcement practices, which is shaping the cases early on. What are the systematic patterns do you see repeatedly influencing who gets charged and how aggressively with what the leverage is?
That's a good question. So I would suggest that the people that are charged the most are the poorest people in any given community. And I say that because if I go in for the call of the list day, most of the people who are there for the call of the list, which is just a kind of a giant cattle call to dispose of cases. What's the status of the case? What are we going to do with it? Are we going to trial? Are we going to have a plea agreement? Or do we have some other resolution of the case? If you go into any given courtroom or peruse the list of any prosecuting attorney, most of those people are going to have a public defender as their attorney. So most of the cases are going to be lower income, low asset people from your community. It's I can even see it in the context of who gets pulled over by the police. So if you have a 2026 brand new Rolls Royce and it's speeding, or you have a 1980 Chevy Chevette that's speeding, you know that if you pull over the Chevy Chevette, that they've got less resources, or you could assume that they have less resources to fight the case, to hire an attorney, to become a problem for this officer. Therefore, you kind of have, if the two of them are driving side by side, you pull over the one that has lower income, or you pull over the one that's from out of state because it's going to be more expensive for them to come back here and defend the case. But these are pragmatic issues for an officer to resolve. You're also going to see a higher prosecution from lower income communities that are plagued with drugs, alcohol, substance abuse, addiction. Almost every case, not every case, but I'd suggest 9 out of 10 cases, it's going to have some issue of drugs or alcohol. It is a major catalyst that keeps our prisons full and keeps the entire system, the courthouse, the probation department, prosecution, defense. There's a million ancillary jobs that are connected to the courthouse, and a lot of it, a very high amount of it, is a direct result of substance abuse and addiction. So that's another, if you're asking me what is a major, what community, it's usually the addicted community. And now we're seeing a rise in something called treatment courts, where the system is kind of acknowledging this finally, thank God. So we have a drug court, or we have a DUI court, or we have a veterans court where we're seeing heroin, fentanyl, naturally alcohol, but these people who are kind of trapped in a world that they can't get out of. It's, again, to use the analogy, it's like a spider web that they can't get out of because they're stuck there due to their substance addiction. So they can't get a job, they can't go to work, they can't function like the rest of us arguably do and should, because they're shackled to the substance, which has all kinds of knock-on effects with regard to their ability to maintain a family, their ability to maintain a place to live, rent, mortgage. If your money is being tied up by this substance and you're stealing or committing assaults, or you have all these other alternative means to secure money and or drugs, very often at the core of it will be this group.
Correct, totally correct. And on that side only, I mean, if you can share, suppose for any average person, I mean, this can feel kind of abstract until it suddenly is not. So, I mean, how do these legal dynamics show up in everyday encounters, like the traffic stops or maybe the routine investigations? Like what?
So you're generally going to only see a traffic stop if it's part of a designated traffic detail. So generally, the officers that are pulling people over were sent out there that day or that night, more often that night. I would suggest anybody being pulled over after 10 p.m. in the United States, they're generally there because they're on essentially a DUI duty. They're kind of looking for people who are under the influence of alcohol or drugs while they're driving. Consequently, they're going to look for signs of impairment while they're driving, touching the fog line, deviating from, crossing the center lane, driving too close to another vehicle, driving way too fast, driving way too slow. And then they pull the vehicle over to cite the person for some minor traffic issue. And then it's, once they've got the person on the side of the road stopped, now they are looking for visible signs of impairment. Glassy, bloodshot eyes, slurred speech, difficulty finding their documents, the registration, their insurance card. Are they able to communicate? Are they able to coherently answer questions? Did they fumble with the paperwork before they handed it out? And naturally, the biggest one of all, did they smell alcohol or smell marijuana? So when you've got this set of circumstances, there's kind of like an underground movement now where people will say, they'll hold up a sign and say, I'm not going to answer any questions. Here's my information. It's already hanging outside the window. Take it and write the citation. I don't want to answer any questions, because once you start answering questions, the officer now is formulating probable cause. So he's got reasonable suspicion to pull you over because of a summary offense, which he can just cite you on the spot or even mail it to you. But as you are interacting more, the more you're speaking, the more they're formulating probable cause to get you out of the vehicle. And once they get you out of the vehicle, they can say, do you mind if we do some sobriety tests, field sobriety tests? So now you get to walk and turn, the one leg stand, horizontal gaze nystagmus with a flashlight. All of these can be used to formulate probable cause, which ultimately leads to bringing you in for a blood or breath examination back at typically, it's not performed at a hospital. They do the blood draws now at like designated blood draw places, typically, the prison or a local place where they'll have a phlebotomist on duty doing nothing but blood draws. And that outcome of the blood draw will be used as to whether or not they bring the case. So sometimes they'll file the case based on everything they saw, and we'll be heading to a preliminary hearing, and I will get a blood draw, and I'll have a client that's adamant, I don't drink, I wasn't under the influence of any drugs, there is no possible way that I was DUI. And I say, well, we're going to have that very, very, very cleared up for us by the time we see the inside of a courtroom. And sure enough, this has happened where I will have zero substance in a person's blood and a very frustrated DA, because the DA, well, they were on something. They were on something new that we haven't come up with to do a test for. And I'll say, well, he did say he's been awake for 2 days, and he had glassy, bloodshot eyes and slurred speech and a series of things that are consistent with someone who's been awake for 2 or 3 days. Lack of sleep, worried about a family member in the hospital or an ability to pay a bill, whatever the case may be. And we have the case dismissed at the preliminary hearing because the blood draw was actually used as a sword for the defense instead of a sword for the prosecution. We can say no. We want that in, and we insist that this be dismissed. You've got no case.
Got it. That's lovely. Thank you so much for clearly mentioning that.
Sure.
Yeah. And like, what are some of the early mistakes that people make simply because they don't understand the stakes or their rights?
Yeah, the biggest mistake people make is speaking, talking, answering questions. You're under no obligation to talk with that officer. And it's become kind of an internet meme from attorneys who will repeat it over and over again. Excuse my French, shut the fuck up. Do not speak. If they say, where are you coming from tonight? You just say, you don't have to tell them, you're not under oath and you're under no obligation to say anything to this officer. You can say, I just felt like going for a drive. You don't have to say, I was coming home from a bar, and open the door to the next question. Did you have any alcohol to drink? Yes, just two. So now you're putting yourself in a spot where before the officer had no idea where you were coming from. And now you just admitted to consuming alcohol. So now you got two. So now he's going to say, well, we have glassy bloodshot eyes, slurred speech, trouble finding our ID, and now we've just admitted to coming from a bar and having alcohol in our system. You don't have to talk to that officer at all. You don't have to say anything. You don't have to be their friend. I would suggest that it's best to always be cordial and polite with the officer. Mind you, they're standing on the side of the road at 1 a.m. You don't need to be rude to them and give them a reason to bring you in, but you sure as heck don't have to tell them, yes, I had 2 drinks and I was on my way home. And people dig a hole by talking to police, and I've had it in homicide cases. Naturally, I've had it in DUI cases, but that police officer is not your friend. They are under no obligation to do you any favors, and very often they are looking to make your life a living hell. So when you start volunteering facts or trying to explain things that they don't even need to know about, you don't need to explain anything. You're an American citizen, free to come and go from wherever you need to. And no, I'm just out for a drive. You don't have to tell them anything. That's the biggest thing I would say is shut your mouth. Don't start trying to get chatty with the cop, because nothing good comes from it. You're not going to charm this officer out of giving you a citation.
So, in suppose in such scenarios when the officer creates a situation to speak, how to avoid that situation?
Just, you can very easily say, I don't want to answer any questions. If you need to ask me any questions, contact my attorney. And then you can get on Google and find an attorney and give them a name and number. You have no obligation to say, I have an attorney on speed dial. I'm not answering any questions, officer. I'm just trying to get home. The end. If you're under arrest, so you can ask, am I being detained? If you're being detained, now they have to read you your Miranda warnings. So if you're being held somewhere and unable to leave, now anything you say can and will be used against you under the law. They have to tell you that. They have to read your Miranda warnings, and anything you say can be part of their basis for bringing the charge. You don't want to do that. If they say, where are you coming from? Sir, I don't want to answer any questions tonight. I'm sorry. I'm very tired. I just want to get home. They'll ask you another question. Sir, I understand you want to talk to me. However, I don't want to answer any questions. I'm just trying to get home. You don't have to give any information whatsoever. That's fully within your right to keep your mouth shut.
Definitely. That's really great point. Yeah. The balance between awareness and restraint seems very, very essential, and especially in the moments that is charged with stress and authority. Right. So,
Yes.
definitely. And so defending people at their worst moments, it carries the emotional weight. So how do you personally stay grounded while working inside a system where the outcomes are not always just?
That is maybe your best question, and it's very difficult to answer. I don't think people understand the weight that a defense attorney carries.
Yeah.
You are the only thing between them and a system that wants to completely destroy them. Okay. And it's in every case. Every case has this tremendous weight. Some cases are heavier than others, but all of them are they're huge. If someone loses their license in the United States, we don't have a public transit system here like they do in other countries. You need a car and you need a driver's license. So if you lose your license and you have a home and a family and a job, it becomes a homicide trial, trying to keep that person able to keep the driver's license in their pocket. And God forbid, if they are stopped while driving a vehicle without their driver's license because it's been suspended, now we're looking at a mandatory 60 days in jail. So now you're looking at an additional 12 months of suspension on your license plus 60 days in jail, and the shame that comes with that. And so your question is about balance, and I have to admit I haven't really found that balance. I live with the stress that this job brings, and I think any defense attorney that does this full time and is if they're being honest, because many of my peers, we will talk candidly, like waiting for our case to be called, waiting to talk to the officer or the DA, and just talk about the crushing stress that these cases bring. Every case is very, very stressful, and you're the only one that can do anything about it. They've put all their trust in you to bring them the best possible resolution, and it is a incredibly heavy thing. That was a very good question.
Exactly. Yeah. Thank you so much. Yeah. And also, like, what helps you maintain clarity? Because I believe you are in that, like you mentioned, for a defense attorney, it's a very stressful part. But what helps you maintain clarity and purpose after decades in high stakes cases?
The clarity, I'm not sure what you mean by clarity, but I'll do my best to answer the questions. The ability to close one case and reopen the next one. And I
Yeah.
have learned from the last one and all the ones leading up to it. So when I've got a new one in front of me, even on the same day, I'd like to tell people that each courtroom is its own microclimate. And each courtroom has a different sense of stress or a sense of levity or a sense of, like, depending on whatever mood the judge is in on that day, or if someone just got in trouble, like a defense attorney, or if a DA just got in trouble with the judge, or a police officer, or there was a belligerent defendant. It completely changes the climate in the courtroom. And you have to be very sensitive to what's going on. So if I'm going to ask for a special dispensation from the judge, this might not be the day to do it. You want to be very sensitive to what's happening in the room. So if I can ask for a continuance, like let things cool down, there's just different things. Or if everybody's in a good mood and super jovial, now is exactly the time to ask for a special dispensation. Oh my gosh, if I was going to ask for a continuance before, I'm not going to, because this is the moment. The judge is in a good mood. The DA is in a good mood. Everybody's happy. They're giving away the farm. My colleagues and I have an expression that give you a great deal on a case. Get it now while there's somebody who just got married, or we're on the cusp of a big holiday, or someone's quitting, like the DA is quitting, and therefore they don't want to have all these cases outstanding. So therefore they just want to look to get rid of some cases. I don't know what that has to do with my personal clarity from case to case, but these things, if you care about your clients and you care about doing a good job and your reputation, remember, every defense attorney that I work with is a person with a family of their own, and we live and die by our reputation. And the relationships that we build with DAs and officers and the judge are of paramount importance. Your integrity means everything. Do they trust you when you say something? Can you be trusted? Can your clients trust you? Can the DA trust you? Can this judge trust you that you're not trying to get one over? That the things that you're saying are true. It's huge. So you want to be a good person so you can continue to, people talk, man. People leave a courtroom and they know, no, this guy actually cared about me. This guy went to bat for me. That's what keeps me focused, is knowing that if I'm not focused, it's going to have a great deal of bearing on my own life. I have to be invested in these cases.
Definitely, I totally agree on this. And so, before we leave, dear listeners, I would love to quickly summarize this thing, like what we discussed today, right? So, the conversation that happened today, it actually reminds us that the understanding how a system works is not just about the fear. And if I'm also right, like it's all about the clarity, the agency, and making the informed choices when they matter the most, right? So also, for the listeners who feel intimidated by the systems and they don't fully understand, what will be the one question they should ask, or maybe they should start asking today, either to themselves or the system, before things escalate? What do you suggest?
So when there's talking with a defense attorney,
Yeah.
I think you want to ascertain whether or not this lawyer is from the area where they're in trouble. So if you've spent 2.5 decades getting to know the players on the stage, and you're well aware of the role that you play on the same stage, that has a very great deal of bearing as to the outcome of the case. As a prosecutor, I very often came across defense attorneys who never did a day of criminal defense work. They have been practicing in the area for decades, but never did a criminal case, had no idea what they were doing, were completely, and this would be somebody who they've seen television commercials for because they're whatever, injury attorney. And now for some reason, they've got a criminal case where they have no idea what they're doing and are asking the prosecutor what they should do. That's not who you want to be asking what you should do, is the prosecutor. They will tell you how to get creamed. They don't
Exactly.
care. They don't care about you or your client. They will tell you exactly, oh, this is how it's going to go.
Yeah.
You don't want that. You want somebody that's been on the stage, enjoys a solid reputation, arguably before you even speak to a defense attorney. You've checked to see that they've got positive reviews and that they practice in the area for which you are hiring them. That's a big
Amazing.
deal. Are they from the area? Do they have relationships built with the prosecution?
Amazing.
Did they help? Did they try to help this judge get elected 5 years ago? These are things arguably that are very, very important that I don't think a lot of people know to ask.
Lovely. Lovely. And where can listeners find you if they want to connect?
Just my website is pennsylvaniadui.attorney. I don't have a book. I don't have a podcast or anything to promote, but I'm just happy to help and answer questions. And it's been a great pleasure being here with you, Avi.
Amazing. So, dear listeners, I'll put all the links and the details into the show notes for your easy reference. And thank you so much for joining on Mind Meets Machine. And if today's conversation gave you a clearer lens on the legal system, then sit with it. Awareness changes how we move through the world.
Well
So,
said.
with this hope, this is your host Avik, and this is Mind Meets Machine. Until next time, stay thoughtful, stay informed, and take care. Thank you so much.
Thank you, sir.